It's officially 2025, and the road to Sean Combs' criminal trial has begun. But it seems both the prosecution and the defense can't seem to agree on a number of key deadlines in this case for when information will be disclosed and arguments will be presented. With all eyes set on a May 5th, 2025 trial, will that still hold? We're going to break down one of the latest filings from both sides in this high-profile case. Welcome to
Diddy and Jay-Z, two of the most powerful names in hip-hop. Billionaire icons, music moguls, cultural giants. But behind the shine and the glitz, there's a story that's darker. A story that's been buried. And now the cracks are showing. These are private gatherings that go way beyond the velvet rope.
The argument could be, let's get this trial over and done with. We think we can win. That's it. Let's put it in the past. But I've also wondered, would that trial date stick with so much going on? Well, I tell you that because the trial date has come into focus once again in a new filing from both the prosecution and the defense. And that is what we're going to break down for you right now, this letter. This letter that was addressed to Judge Arun Subramanian of the Southern District of New York, the judge overseeing this criminal case. And in this joint letter submitted by both parties, it discusses the pre-trial schedule, so everything leading up to the trial. And by the way, you might be saying this seems boring. No. The reason this is so important, the reason these dates are so important is, aside from the fact that it kind of gives us a sense of the strategy of both the prosecution and the defense, is because those dates are so important because if those dates hold, whichever side we're going to be going through, if the judge decides with the prosecution or the defense, or there's times they consented to a date, that is giving us a window of when and if we can learn some new key details about this prosecution and defense. So much of this case has been wrapped up in mystery in terms of the actual events, the witnesses, the victims, the defenses. So if these dates stick, we now have a timeline of when things might be presented and what things might be presented. This is important. So now the question is, what is this pretrial schedule? Well, as the lawyers lay out in this joint letter to the court, they write, the court set the following pretrial motion schedule. Motions due on February 17th, 2025, oppositions due on March 3rd, 2025, and replies due on March 10th, 2025. Again, this is all leading up to the May 5th, 2025 trial. Now, the prosecution and the defense have two different perspectives on this schedule, and I'm going to start with the prosecution. They write, given the May 5th, 2025 trial date in this case, the government respectfully submits that the current pretrial motion schedule, in which the pretrial motions would be fully briefed less than 2 months prior to trial, will not permit the parties to raise and the court to resolve pretrial issues sufficiently in advance of the May 5th, 2025 trial. While the defendant is fully entitled to request a speedy trial, that does not mean that he's entitled to demand disclosure deadlines appropriate in cases with significantly longer timelines. Accordingly, the government objects to any schedule, including that proposed by the defendant, requiring the government to make trial disclosures before the filing and/or resolution of pretrial motions which may shape or affect those disclosures, including by affecting the scope of the charges or the evidence the government is permitted to rely upon in its case in chief. Okay, so a lot of legalese. What does all that mean? Well, basically the prosecution is saying, look, there are a lot of filings and issues that need to be resolved before trial, which, by the way, I will get into. But essentially, the government is saying on the current schedule, there's not enough time to sort all this out. And even though Sean Combs has a right to a speedy trial that's enshrined in the Sixth Amendment, protects against undue or unreasonable delays in criminal cases, even though Combs has that right, the prosecution argues it doesn't mean we have to disclose certain aspects of this case prematurely. We shouldn't have to turn over things earlier than we would in other federal cases, and it's too premature for us to disclose certain things before we even resolve some important pretrial issues.
Parties shrouded in secrecy, protected by wealth and silence. They're more than celebrity hangouts. They're what insiders now call freak-off nights. Nights where the rules vanish and silence becomes the currency. Multiple insiders, former assistants, bodyguards, creatives, are starting to talk. They describe scenes more like it belongs in a nightmare than a mansion. Elite venues, confiscated phones, strict non-disclosure agreements. Attendees walk in blind. The themes get darker as the night goes on. And both Diddy and Jay-Z, they're involved, not always as the overt hosts, but always present. Diddy's name comes up most often. Rumors have swirled for years. Artists cut ties without explanation. Employees vanished from the public eye. And the narrative that emerges is one of power used to shape silence. These parties, sources say, weren't just about indulgence. They were about influence and control, about knowing who stays quiet.
3 weeks before trial, April 14th, 2025. They say earlier than that doesn't make sense because those motions in limine excluding evidence or arguments won't have been decided yet, and that will affect who or what the government will present. They say the defense can present its list by April 25th, 2025, so that's 1 week in advance of trial. The defense agrees to both. And then both the prosecution and the defense agree to April 11th as the deadline for the jury questionnaire forms. So those are sent out to prospective jurors across the jurisdiction. Starts the whole jury selection process on who will be called into court for further questioning and examination. And also both sides agree to April 25th as the deadline for requests to charge or voir dire. That's the more specific process for selecting the jury, and also proposed verdict forms to be submitted. So in the end, what do you see here? You see a little gamesmanship, you see a little strategy, a little practical difficulties all at play here. Remember, it is the prosecution's burden. The defense arguably wants to trip them up, right? They don't want them to be as prepared as possible, trying to take any advantage they can. So this unidentified Jane Doe has sued both JayZ, Sean Carter, and Sean Diddy Combs. This is out in New York. This is out in New York federal court, to be more specific. And she is claiming that when she was just 13 years old, she was raped by both of these musicians at a Video Music Awards after party back in 2000. And now JayZ, who is adamantly denying the allegations, is not only trying to get the whole case dismissed and thrown out, but he is also asking the court to impose sanctions upon Jane Doe's Texas attorney, Tony Buzbee. Now, this may sound very familiar, by the way, because this has been an ongoing legal war between Buzbee and JayZ and his legal team. Accusations that Buzbee engaged in extortion, that his firm pressured a client to lie, that JayZ's camp has been engaging in intimidation and harassment. JayZ called Tony Buzbee a deplorable human being. He even filed a lawsuit against Tony Buzbee. And by the way, JayZ and his legal team, their position was that Buzbee had extorted the rapper, that Buzbee allegedly threatened JayZ during negotiations that he would go public with these claims. JayZ says these are false claims, but public with these claims unless JayZ agreed to pay what they claim is a, quote, exorbitant sum in private mediation within a 2-week period. JayZ says that when he refused, that is when he was named by Tony Buzbee in the lawsuit. Remember, this lawsuit first came out. It was only identified as unnamed celebrity A, and then in an amended complaint, JayZ was identified as celebrity A. So you're seeing this really bad blood between the different players here. I mean, it got so bad that the judge in this case, Judge Annalisa Torres, actually scolded JayZ's lawyer, Alex Spiro, writing in a recent order, Carter's lawyer's relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. Now, despite not allowing JayZ to immediately file for sanctions, Judge Torres did permit JayZ to file the motion that we're about to talk about. And this is big. So this is JayZ's memorandum of law in support of his motion for sanctions and dismissing the complaint. So basically, these are his legal arguments. So the filing begins right on page 1. While the allegations stated in the complaint in this case are gravely serious and injurious to Mr. Carter's hard-won reputation, many of them, on their face, strain the outer bounds of credulity, and none of them appear to have been subjected to even the most rudimentary diligence by the filing attorney who initially signed his name to them and has since declined to withdraw them. Because the federal rules and professional ethics require more of a filing attorney, Mr. Carter now respectfully seeks appropriate sanctions. And by the way, when we're talking about
JayZ has built his empire quietly. He's about strategy. He plays chess while others play checkers. But even he is being tied to these events. Some say he distanced himself as things got darker. Others say he helped maintain the secrecy. Not the ringleader, but very aware of the game. What's chilling is what people describe when they speak. Different names, different times, same structure, same patterns. Career deals offered for cooperation, access denied for questioning the system, silence rewarded, curiosity punished. And right at the center, Diddy and Jay-Z's power. This isn't about cancel culture. This is about a systematic web of silence. People staying quiet for years. Now, as legal scrutiny ramps up around Diddy and Jay-Z steps into larger global arenas, the quiet is breaking. Let me lay it out raw. Locations shift.
Testified to George Kaplan, Mia, David James, is that they did work very, very long hours, 80 to 100 hours per week. And for everyone who knows, around the normal time frame, it's about 40 hours per week for us regular folks. But for Diddy's staff and especially his assistants, they were to put in the long hours. That was kind of their requirement. And they always had to be on call, according to Brendan Paul. But he says for his time frame working with Sean Combs that he only worked about 4 to 6 days per week, which is still a long amount of time. He says around the start of his employment, he was making about $75,000. And then towards the end, beginning in January of 2024, he was making around six figures, $100,000 working as a personal assistant. And so we saw kind of the exhibit as far as the spreadsheet goes, and it was just the pay assigned to the different assistants. And we saw how much Brendan Paul was making in his biweekly paycheck, which were about $4,000. Then they kind of start to get into a little bit of just more that the role entailed, such as drug use, such as traveling, such as, things like club appearances, where Diddy said he would do club appearances for also six figures, around $150,000, and that he didn't do it as much when Brendan Paul had been working with Diddy. He says that Diddy only did them maybe about 8 times during his 18-month employment. And so it seems like even though Diddy and Brendan Paul may have on surface had a good relationship, Brendan Paul also mentioned, like other assistants, that Diddy had fired him a couple of times. And again, he'd only worked for Diddy for about an 18-month period, but Brendan Paul testified that he had gotten fired about 2 to 3 times during his employment. He said there was one particular instance that happened in October or November of 2023 where he said he forgot Diddy's Lululemon fanny pack. And I thought that was kind of interesting. And so what Brendan Paul did was he went to Lululemon, which, by the way, is like kind of for those who don't know, and I think a lot of people know what it is, it's like an activewear type of store, very expensive, very pricey, and they have great yoga pants, by the way. But anyway, that Brendan Paul actually went to Lululemon to purchase a fanny pack for Diddy because Diddy was upset that the Lulu fanny pack wasn't given to him by Brendan Paul. He said that this was one of the few instances where he saw Diddy get very angry in terms of his demeanor goes. Brendan Paul says the reason he got his job back after being fired for just kind of a brief moment is because Christina Courtroom told him to advance a room for London. And Brendan Paul mentioned that HR a couple of times during his employment forgot to pull his taxes, at least for the first 6 to 8 months that he was working with Sean Combs. And he says that if there was ever an issue that normally HR would be involved in, it wasn't that case kind of working for Sean Combs. Instead, if there was an issue, that he would either go to Christina Courtroom or he would go to Sean Combs directly. And he never really worked or never really saw HR in that type of capacity kind of take over.
Right.
And I thought that was kind of an interesting point, especially given that, the defense may feel like a little different of a way.
Well, here's the thing. It seems to me a couple things from this. Number one, forced labor is one of the underlying predicate crimes of racketeering that the prosecution is hoping to prove. So when you hear about these extreme working conditions, we heard it, also from Mia. We heard it from other witnesses. Mia said she was sexually assaulted by Sean Combs when she was working for him. That would help to maybe prove that. But also
Mansions, penthouse suites, remote estates. No press, no cameras. Phones collected at the door. GPS encrypted addresses. Guests told to arrive blind, sign NDAS first. Then enter a world where control is literal. Inside, rooms are themed. What begins as upscale cocktail lounges morphs into masked spaces. Mirrors, hidden chambers, elements of bondage. The message is clear. Participation is obedience, and silence is mandatory. The guest lists read like a who's who of influence. Celebrities, executives, political figures, artists who are still climbing, people with ambition and something to lose. They're curated carefully. No moral objections, no dissent, only compliance. You play by the rules and you're rewarded. You question and you're pushed out. Diddy's inner circle enforces loyalty with obsession. Rise through compliance, fall through resistance. Former assistants speak of offers made quietly in the dark, promotions, visibility. And when you stop playing along, you're erased, vanished from the map. On JayZ's side, the removal is subtle. He doesn't front it publicly, but people say he approves guest lists, filters access, decides who gets brand deals, platform, or visibility, and who disappears into the background. Control by omission. Then there are the people who fell. Artists, creatives, managers who vanished. People who were in Diddy's orbit, then gone without explanation. Some say they left on principle. Others say they were quietly edged out. Insiders recount it in chilling detail. Careers paused, visibility revoked, lives rerouted. Hush money? Not blockbuster Hollywood payouts, but enough to keep mouths closed. Enough cash to enforce NDA compliance. Contracts that forbid naming, sharing, even implying. A web of silence stitched with signatures and fear. But people are talking now. Off the record. They say they're torn. Between loyalty, ambition, fear. They know what speaking out could cost, but the weight of silence is heavier. As stories emerge, more voices join. The once silent begin to speak. Why now? Because Diddy is under legal scrutiny. Litigations. Allegations. And JayZ is stepping further into politics, philanthropy, global discourse.
It's false. And what they do is they point to previous filings that show there was no Jumbotron for the award show because that permit was denied. Later on in the paperwork, the defense says, plaintiff denies Mr. Carter's evidence that she could not possibly have watched the VMAs on a Jumbotron or spoken with limousine drivers, but plaintiff could not have watched on a Jumbotron in Times Square because per the FAC, she was not in Times Square, Broadway and 42nd Street, but outside Radio City, that's 5th Avenue and 50th Street. That's nearly a mile away. And the denial of MTV's permit prevented it from being telecast in Times Square. So that's directly addressing Busby's response that, well, she might have watched it in Times Square and got confused. And then also addressing another response from Tony Busby that, you know, the limousines might have been elsewhere and not in this cordoned off area where she couldn't have gotten access. Well, JayZ's team says, nor could the limousines have been elsewhere because per the FAC, she approached them while standing outside Radio City watching the VMAs. If nothing else, these inconsistencies should have been run to ground before Mr. Busby sponsored allegations that could not withstand a simple Google search. By the way, Tony Busby has responded that this is not the time to throw out this case. We've made allegations. Obviously, another side is going to dispute them. In any litigation, there's going to be a dispute about what happened. This should progress. This should advance. We should have discovery and allow us to make our case. Moving on. The defense claims, again, JayZ claims, that allegations 3 and 4 concerning the limo driver and the large white residence with a U-shaped driveway where, again, Jane Doe says that she was raped, these allegations are false. So JayZ's attorneys concede that Combs did own a large white residence, but said it does not have a gated U-shaped driveway and is located in East Hampton, a minimum 2-hour drive and over 100 miles from Manhattan. Jane Doe also says that she had to sign what she thinks was an NDA, a non-disclosure agreement. Well, JayZ's team says that was not fact-checked and that Jane Doe lacked such a document. Jane Doe also claimed that she spoke with celebrities at the party, but the filing lists that as false or highly suspect because she alleges that she specifically remembers speaking with Benji Madden of the band Good Charlotte, but Madden's people say he was doing a show in another state that night. The 7th allegation is that the plaintiff was purportedly drugged and found a room to lay down in. The filing says that can't be fact-checked. Plaintiff told no one for 24 years and did not undergo toxicology screening. So the defense says they also can't fact-check that Jane Doe ran from the house to a gas station because, again, the plaintiff told no one for decades and now claims not to know the resident's location, let alone the gas station. So could this be a case that is allowed to proceed forward just on her account? Sure, but that might not be the strongest account. But finally,
As they expand their platforms, scrutiny sharpens. Whispers no longer stay whispers when the spotlight gets bigger. This is about institutions. It implicates labels, media, politics, brand power. There's an ecosystem set to protect, to hide, to reward silence and compliance. Artists learn early that ascension often means complicity. Managers ask whether they're enabling. Journalists and executives confront lines of influence. And fans? Culture? If icons operate in shadows, what does it say about the pedestal we made? About the stories we believed? When legends turn the lights off and still expect applause, it's time to question the architecture. Key principles stand out. Secrecy breeds corruption. Power fortified with NDAs and hush agreements becomes weaponized. When independent insiders share the same script, repetition isn't coincidence. It's evidence. This isn't drama. It's structured, built, and only now fracturing in public. Unspoken questions linger. How many careers ended because someone refused? How many insiders stayed silent to survive? How many lives were rerouted in the interest of common compliance? Skeptics ask, can this be true? You see people speaking up. You see patterns repeat. People walk away. The hosts keep walking. But the stories are too consistent to ignore. This piece isn't sensationalism. It's a call for accountability, exposing systems that shield influence. As more stories surface, as more pressure builds, we approach a reckoning. Power must answer. Transparency must follow. Those who believe in fairness and justice, this is your invitation to bear witness. Support voices that were silenced. Demand openness. Diddy and Jay-Z built empires that shaped culture. But no empire is built without shadows. What's unraveling now is not rumor. It's pattern, multiplied voices, fear shifting into defiance. The empire isn't just in their hands anymore. The truth is in movement.